All rise, veuillez vous lever. Please be seated, veuillez vous asseoir.
Yes, Ms. Laji.
Thank you, Madam President. I have only one word of reply to add that is not covered in my submission, so I address it here, now. This is with respect to the Lukic case. I referred to it, if you remember, on Monday. It's the transcript 164 ET, page 86, lines 19 to 23. And I mentioned the Lukic case precisely to illustrate that extermination, which Lukic was found guilty of, was a crime of extreme gravity. Lukic was sentenced to life. This was upheld in appeal on extermination count. On Monday, in the opening of my oral submissions, I referred to the views and concerns of victims as reflected in the legal representatives' submissions, written submissions. These were repeated this morning by my learned friend, so I don't need to repeat these again. Just no vengeance, justice, the just and fair application of the law. This is what is expected from you, Your Honors. This is what is expected from the court. The application of the law is enshrined in the Rome Statute. As I said also on Monday, this court is the beacon of international criminal justice. As such, it is crucial that it enforces the highest standards of criminal justice and fair trial. In the case of Mr. Abd-Al-Rahman, this role is devolved to you, Your Honors. The beacon is your beacon. If it succeeds in doing so, in implementing the highest standards provided in the statute, your beacon will lead state parties towards the safe havens of compliance with the rule of law where democracies flourish. Should it fail in giving flesh and effectivity to these fundamental principles of criminal justice, your beacon will mislead the state parties on the dangerous reefs where the rule of law and democracies are sinking. The time has come, Your Honors, for you to tell us where your beacon is leading us. Is it the safe havens where democracies flourish? Or is it the dangerous reefs where the democracies sink? It is your choice, and it is ultimately the most fundamental aspect of the determination that you have to make. Among the most fundamental, non-derogable principles of international criminal justice The appeals chamber used the words jus cogens to describe these, are those enshrined in Article 22 to 24 of the Rome Statute. Nullium crimen, nullia pena sine lege, and the non-retroactivity ratione personae of criminal laws. With respect to sentencing, compliance with these principles requires that in the event of a change in the law applicable to a given case prior to a final judgment, the law more favorable to the person being convicted shall apply. That is Article 24, paragraph 2 of the Rome Statute. The insertion of the principle of non-retroactivity ratione personae was an innovation in 1998, a significant progress, turning the page of ex post facto international tribunals created by the international community in Nuremberg, Tokyo, the former Yugoslavia, Rwanda, Sierra Leone, Cambodia, Lebanon, and others. That was to fill the gap of the absence of a truly permanent international court. The principle of non-retroactivity ratione personae did not exist before these other tribunals. There is thus no mystery if in Blaskic, as cited by my learned LLV friend on Monday, or in Galic, as cited by the OTP this morning, the principle of non-retroactivity did not appear. The only relevance of quoting Blaskic or Galic is precisely to emphasize the added value of Article 24, paragraph 2 of the statute compared to these other tribunals, which were ex post facto. At paragraph 123 of its written submissions, the defense has referred to the relevant case law of regional courts in charge of enforcing human rights in relation to non-retroactivity ratione personae. These courts are unanimous. The European Court's Grand Chamber in Del Rio Prada versus Spain, the African Court in Kabalabala Kadumbagula versus Tanzania, and the American Court in Velez-Loor versus Panama all find that the punishment imposed on a convict shall not exceed the limits fixed by the provisions in force at the time of his action. The same principle applies to all crimes, irrespective of their gravity. We referred to a judgment from the Supreme Court of Benin in relation to a mundane traffic offense. But we also quoted the European Court's Grand Chamber in Maktuf and Damjanovic versus Bosnia and Herzegovina. This was a war crimes and crimes against humanity related case. So even for the most serious crimes of concern to the international community as a whole, the crimes under the jurisdiction of this court, the principle of non-retroactivity ratione personae applies, according to the European Court of Human Rights. Their gravity does not make them an exception to this principle. The only case law from this court that the defense was able to identify, but it seems that the other parties were not more successful, is paragraph 303 of the decision on the confirmation of charges in the Lubanga case, It is quoted at paragraph 121 of the defense sentencing submissions. I read it. There is no infringement of the principle of legality if the chamber exercises its power to decide whether Mr. Thomas Lubanga Diallo ought to be committed for trial on the basis of written lex scripta, pre-existing criminal norms approved by the state parties to the Rome Statute, lex previa, defining prohibited conduct and setting out the related sentence, lex certa, which cannot be interpreted by analogy in malam partem, lex stricta. I believe my learned friend on the legal representative side missed this reference on Monday. It's transcript 0164 ET, page 61, lines 20 to 25, when she said that there is a consensus that nulla pena principle does not bear the requirement of lex certa, that is, specific sanctions. Nulla pena sine lege does require lex certa. When the Rome Statute is applicable, like in Lubanga, this requirement is fulfilled by Article 77 of the Rome Statute. When the Rome Statute is not applicable, like in Sudan in 2003 and 2004, the appeals chamber has told us in its judgment OA8 that we should look beyond the statute, in the law that was applicable at the time. This is what your honors did in the trial judgment by looking at the Sudanese 1991 Criminal Act. I submit that consistency with the trial judgment requires your honors to follow the same path now with respect to penalties. What are the consequences of this fundamental principle on the case of Mr. Abd-Al-Rahman? The crime he has been convicted for were committed in 2003 and 2004. In that time, Sudan was not a state party to the Rome Statute. It is still not. This makes that there was no link between Mr. Abd-Al-Rahman, a Sudanese citizen acting on the territory of Sudan, and the law of the court at the time of the crimes. The law of the court, the Rome Statute, was not applicable to him. What made the Rome Statute applicable to Mr. Abd-Al-Rahman is Resolution 1593, passed by the UN Security Council on 31st of March 2005. This is the pivotal date. From that date on, the Rome Statute became applicable to all nationals of Sudan and to all crimes committed in Sudan. This constituted a change in the law applicable to Mr. Abd-Al-Rahman pursuant to Article 24, paragraph 2 of the statute. On Monday, my learned friend on the legal representative of victims' side suggested that Resolution 1593 did not amount to a change in the law applicable pursuant to Article 24, paragraph 2. This is the transcript of Monday 164 ET, page 64, line 19 to page 65, line 4. According to submissions, the only possible change in the law that may trigger non-retroactivity ratione personae under Article 24, paragraph 2 would be an amendment to the Rome Statute. I pause a minute to consider the argument before turning to the clear and unambiguous answer provided by the appeals chamber. An amendment to the Rome Statute is not labeled a change in the law in the Rome Statute. It is called an amendment. You can see that at Article 121 of the Rome Statute. Also, the statute itself is not called the law, but the statute. If the intention of the drafters of the statute would have been to limit the scope of Article 24, paragraph 2, to the occurrence of an amendment, they would have used that word. Article 24, paragraph 2 would read, in the event of an amendment to the statute, but not as it does in the event of a change in the law.
Just pausing there for a minute, Mr. Latch, you assert that with great force, if I may say so. Do you have any authority for saying that?
For saying?
For saying that had the statute intended that it meant a change to the statute, it would have said an amendment to the statute rather than a change in the law.
I'm referring to the plain and normal meaning of the words. An amendment is an amendment, and Article 121 confirms that. The law is the law, and it's not only the statute.
Okay, you don't have any authority for saying that, is the simple answer. This is your reading of
Yes.
Thank you.
I can concede that an amendment to the statute changes the law. But these are not, and by far, the only possible changes in the law. Restricting the scope, maybe what I'm going to say will answer your question, Madam President. Restricting the scope of Article 24, paragraph 2, to the sole occurrence of an amendment, as proposed, is nothing else than emptying the principle of non-retroactivity ratione personae from the essential of its substance in a total opposite direction from the case law of the European Court, African Court, and American Court that I quoted earlier. Follow that restrictive interpretation, Your Honours, and your beacon will lead us straight on the perilous reefs of authoritarianism and non-respect for the rule of law that I mentioned earlier. Your Honours don't want that. Even if the findings of the trial judgment were right, retribution to the old man sitting behind me would not be worth that. Also, my learned friend omits that Article 24 is not entitled non-retroactivity. It is entitled non-retroactivity ratione personae. What is, and I ask this out of pure rhetoric, the ratione personae dimension of an amendment to the Rome Statute? Can an amendment be ratione personae? Would state parties bother amending the Rome Statute vis-à-vis a specific individual, like, for instance, Mr. Abd-Al-Rahman? The ratione personae qualificative is proof that the non-retroactivity of relevance here is the non-retroactivity of the law applicable to the convicted person, any law applicable to him. It can be his national law, or it can be the Rome Statute, as clarified by the appeals chamber. And by the way, this morning, my colleague from the Office of the Prosecutor acknowledged and confirmed what I just said. I quote from page 2, lines 7 to 9 of today's transcript. Following the referral of the situation in Darfur to the court by the Security Council, the Rome Statute, the rules of this court are the only applicable framework for sentencing. We fully agree, following the resolution, not before. In its judgment OA8, the appeals chamber was considering the application of the principle nullium crimen under Article 22 of the statute. But its ruling applies similarly to the application of the correlated principle of non-retroactivity ratione personae under Article 24. These are inseparable. The law and case law referred to by the appeals chamber at paragraph 84 and 85 of the OA8 judgment encapsulate both without distinction. And what the appeals chamber has to say is the following. I am quoting paragraph 86. For conduct that takes place on the territory of a state that is not a party to the statute, it is not enough that the crimes charged can be found in the text of the statute. In interpreting Article 22, paragraph 1 of the statute in a manner consistent with human rights law, a chamber must look beyond the statute to the criminal laws applicable to the suspect or accused at the time the conduct took place. End of quote. For non-state parties, the statute is not enough. The chamber must look at the criminal laws applicable to the convict at the time of his conduct, that is, in 2003 and 2004. Why that? Precisely because the statute was not applicable to these non-state parties prior to the UN Security Council resolution referring the situation on their territory to the court. This, once again, is the pivotal date. Before the resolution, the statute does not apply. After the resolution, the statute does apply. For nationals of the relevant state, not state party, that amounts to a change in the law. Until 30th of March 2005, no Rome Statute applicable in Sudan to Sudanese people. As of 31st March 2005, they become liable for the crimes under the jurisdiction of the court with no more requirements of foreseeability or accessibility.
Do you know, I don't want to interrupt, but this is exactly what you argued before the appeals chamber delivered its judgment, that there was no jurisdiction to try your client.
My submissions back in this time were related to Article 22, nullium crimen sine lege.
Yes.
My submission of today is related to Article 24, paragraph 2, non-retroactivity ratione personae.
All right, so you're saying totally different principles applied to that than applied to your argument on before the appeals chamber.
I say that nullium crimen, nullia pena, and non-retroactivity are the same facets of the principle of legality, but the way these have to be addressed, indeed, by this court are different, and I'm coming to this.
All right.
Your Honours have applied this judgment, OA8, at paragraph 28 to 60 of your trial judgment. As instructed by the appeals chamber, you have looked beyond the statute to the relevant applicable law in 2003 and 2004 in Sudan, that is the 1998 Constitution, the 1991 Criminal Act, and the 1986 People's Armed Forces Act. These were in force. These were applicable. At paragraph 34 of your trial judgment, you find, I quote, the 1991 Criminal Act unambiguously described the prohibited conduct and defined the crimes. End of quote. And you refer in footnote 46 to various provisions of the 1991 Criminal Act. This is the way your Honours reached the conclusion that the nullium crimen sine lege standard was satisfied. Now, turning to the non-retroactivity ratione personae aspect with respect to the determination and sentence, Judgment OA8 similarly requires you to look beyond the statute to the criminal laws applicable to Mr. Abd-Al-Rahman in 2003 and 2004, those which provided the penalties applicable for these crimes. But, and this is where I answer your question, Madam President, if there is one difference between the principle nullium crimen nullia pena sine lege and the non-retroactivity ratione personae principle, it is precisely the applicability and relevance of the foreseeability and accessibility test. This test applies to nullium crimen and nullia pena. It requires that the person must have been aware of the criminal nature of his acts and of the penalties punishing it. But there is nothing such in the non-retroactivity ratione personae principle. What the person knows and can foresee does not matter. Unlike what my learned friend on the legal representative bench told you on Monday, transcript 164 ET, page 62, line 3 to 22, and my learned friend in the OTP this morning, I'm at page 12 of the transcript, line 15 to page 14, line 8. So unlike what they said, whether Mr. Abd-Al-Rahman was aware of the penalties under the Rome Statute or not in 2003 and 2004 bears no relevance. It is no longer a subjective test. It is a very objective rule. In case of change in the law defining the penalties for his acts, the more favorable, more lenient law shall prevail, irrespective of the offender being aware of that change or not. So the non-retroactivity ratione personae test does not require you to run again a foreseeability, accessibility test into your sentencing judgment. It is much simpler than that. It only requires you to compare the penalties under the statute, Article 77, with the penalties that applied in Sudan in 2003 and 2004, and then opt for the most lenient of the two. To assist you in this exercise, the defense called back witness D16. His written statement is in evidence, and he appeared before you yesterday morning. The Office of the Prosecutor and the legal representative of victims chose not to cross-examine witness D16 according to your owner's rule, I quote, that if the non-calling party challenged the accuracy or veracity of the evidence being given by a witness, then this challenge should be included in the questioning of the witness. That's your trial judgment, paragraph 199. The fact that they did not cross-examine witness D16 means that they do not challenge his evidence. For each crime Mr. Abd-Al-Rahman is found guilty of, witness D16 is telling which penalty was applicable, in his opinion, in Sudan in 2003 and 2004. His responses do not rely only on the 1991 Criminal Act. He is also seeking responses in the 1986 People's Armed Forces Act, whenever necessary to complete the first. I compared yesterday his responses with the OTP's submission on applicable sentences. Can we have the slide again, please? And this time it has been corrected. I'm said it's not on the screen, the desk screen. Okay, I don't need it. Here it is. So you have seen this chart already. This was the first part of the exercise. On the basis of the responses from witness D16 in the right column, the defense submits that the heaviest individual sentence that a convict may be imposed for the crimes is a term of 14 years imprisonment. That's the proposal of OTP under count 1 in the left column. Mr. Abd-Al-Rahman may also be imposed lower sentences for the other counts. If we stopped here, Your Honours may impose to Mr. Abd-Al-Rahman individual sentences up to a maximum of 14 years proposed by the prosecution under count 1 and lower sentences with respect to other counts. The sentences would fall within the category of the more lenient penalties applicable to him before and after the change in the law dated 31st of March 2005. Your Honours may then impose a joint sentence of no less than 14 years imprisonment and reaching a maximum that could theoretically go up to 30 years pursuant to Article 78, paragraph 3 of the Rome Statute, under the condition that you would find a proper justification for stepping over the gap between 14 and 30 years. But there is a second part to this exercise. It consists in applying the law on sentences to Mr. Abd-Al-Rahman. If I manage to get and keep the attention of your owners this morning, they may have noticed that my demonstration so far was on the applicable principle without applying to the specific case of my client. I do that now. The crux of the matter when applying this principle to him is his age, 76 years. As found by your owners in the trial judgment, the applicable law includes, in the first place, the 1991 Criminal Act. And on sentencing, the 1991 Criminal Act contains a provision, that is Article 33, paragraph 4, which excludes the passing of a sentence of imprisonment upon a person who has reached the age of 70 years. It is on the screen. Thank you. Let me read it. With the exception of armed robbery, IRABA, the imprisonment penalty may not be passed upon a person who is 70 years of age, and where the term of imprisonment is retracted or remitted by reason of attainment of 70 years of age, there shall apply to the offender the penalty of expatriation for the term of imprisonment prescribed. I hope that the plain reading of Article 33, paragraph 4 will bring clarity to my learned legal representative for victims friend as to the applicable exception to the rule excluding imprisonment after 17 years, that the transcript of Monday T164, page 63, line 16, to page 64, line 8. The only exception is the offense of IRABA, not murder, not rape, IRABA only. The provision is clear. The imprisonment penalty may not be passed. This is not a mechanism converting a term of imprisonment that is imposed on a convict older than 70 years into something else. It is a provision forbidding, in the first place, the imposition of term of imprisonment on a convict who is older than 70 on the day of the sentencing judgment. This conversion mechanism, requiring the taking of another decision, converting imprisonment into expatriation, is only used when the convict reaches 70 years of age while serving his term of imprisonment. In that case, and in that case only, there is a need for another decision to retract or remit the term of imprisonment. But when the convict is already older than 70 years at the time of determining his sentence, like Mr. Abd-Al-Rahman, no term of imprisonment is possible. The only exception is imprisonment imposed for Iraba. Under Article 1681C of the 1991 Criminal Act, Iraba can, as an option, be punished by a term not exceeding 7 years of imprisonment. In its written statement, witness D16 is providing evidence assisting the Chamber in its determination as to whether Iraba may be analogous to Count 4 pillaging as a war crime. I intended to explore this aspect further with witness D16 yesterday, but I did not have that opportunity.
You could have explored that. You decided to wait because you thought there was going to be cross-examination. So I'm afraid that was your mistake.
Thank you, Madam President. I will nevertheless limit my demonstration on witness D16's second written statement, which is in evidence and is not challenged by the prosecution. Based on his evidence and on the definition of Iraba under Article 167 of the 1991 Criminal Act, the defense submits that Iraba differs from Count 4 on at least two aspects. Can we have it on the screen? Here it is. First, as found at paragraph 370 to 376 of the trial judgment, Kodum, Bindisi, qualified as urban areas, whereas Iraba is committed away from urbanization, whether on land, water, or air. Second, the attacks were launched in the presence of members of the Central Reserve Forces. We have that at paragraph 404, 416, and 420 of the trial judgment. About the CRF, your honors found that they were an integral part of the police forces and as such were governed by the Police Act. That's paragraph 310 of your judgment. In Sudan, like in any other country, the basic function of the police is to maintain order, to prevent the commission of offenses, and to arrest offenders. Iraba is precisely committed when the targeted victims are without any rescue. At paragraph 32 of his second written statement, witness D16 clarifies what without any rescue means. I quote, "It means in the absence of governmental, police, armed forces, any other authority like Sheikh or Umdas that could and should intervene to protect the victims of the Iraba offenders. This is when the offenders take advantage of the absence of government, police, armed forces, or any other authority like Sheikh or Umdas to commit armed robbery. If governmental police or armed forces are present, they should rescue or protect the victims. There is thus no Iraba, but capital theft or simple robbery under Article 170 or Article 175 in such a case," end of quote. All this was witness D16. This evidence was not challenged by the prosecution. The fact that the CRF did not protect the population of Kodum and Bindisi, but actually participated in the attack, as you found in your judgment, is immaterial. The important is that the attackers did not take advantage of the absence of law enforcement forces. law enforcement forces, the CRF, were present during the attack. For at least these two reasons, commission in urban area and in the presence of CRF forces count for pillaging as a war crime could not constitute iraba under the Sudanese law applicable in 2003 and 2004, but fell under the offenses of capital theft, Article 170, or robbery, Article 175 of the Criminal Act. The maximum 7 years sentence for iraba under Article 168(1)(c of the 1991 Criminal Act thus does not apply. The iraba exception to the exclusion of imprisonment sentence for convicts under 70 years of age is therefore not applicable. Which led me to prepare a slightly amended chart that is now on your screen with a third column on the right, which is the applicable law in 2003 and 2004 to a person who, at the time of your sentencing judgment, would be above 70 years of age. This is the same, again, the same chart that you have already seen, comparing OTP proposals with witness D16's evidence. We now have this third column for convicts over 70 years of age, pursuant to Article 33, Paragraph 4 of the 1991 Criminal Act, in the last column on the right. As you can see, the most lenient of the three solutions between OTP proposals, witness D16's analysis of the counts, and the application of Article 33, Paragraph 4 of the 1991 Criminal Act is always found in the last column on the right. Under Article 24, Paragraph 2 of the Rome Statute, this most lenient penalty applicable to Mr. Abd-Al-Rahman in 2003 and 2004 shall be preferred. As a result of Article 33, Paragraph 4 of the 1991 Criminal Act, in the absence of iraba, there is thus no term of imprisonment that can be imposed on Mr. Abd-Al-Rahman in light of his age, 76 years old. That's the defense conclusion in principle. In the alternative, should I have failed this morning in my demonstration that iraba did not apply, the highest term that your owners may apply is 7 years under count 4. In the absence of applicable imprisonment sentence for the other counts, Article 78, Paragraph 3 would not apply, so no joint sentence. Even in that case, the maximum prison sentence compatible with the principle of non-retroactivity ratione personae would be 7 years. As the defense envisaged at paragraph 137 of its written submissions, your owners may also be tempted to look at all these things in a radically different way and decide that whatever Sudanese law provides, the law applicable before this court is the statute, and that the only applicable sentences are those of Article 77, and that these are sufficient for your determination. The issue would look much simpler. No need to question Sudanese law. Your owners apply Article 77, Paragraph 1, and impose a sentence not exceeding 30 years of imprisonment or life imprisonment. End of the story. But the statute to which your owners would give prevalence under this reasoning includes Article 24, Paragraph 2, non-retroactivity ratione personae, and this article of the statute requires in the event of a change in the law, the application of the more lenient penalty to the convict. There was a change in the law. The appeals chamber told you so in its judgment OA8. Before 31st of March 2005, the statute was not applicable. This is the reason why your owners had to go through their determination of nullium crimen sine lege in the trial judgment. There would have been no need for that exercise had the statute been applicable to Mr. Abd-Al-Rahman in 2003 and 2004. This change in the law requires you now to look at the more lenient penalties in concur, and as far as imprisonment is concerned, the Sudanese law excluding imprisonment for convicts of 70 years and more is by far the most lenient. The application of the statute can lead to no other conclusion unless the beacon that your owners embody elects to lead us towards the perilous direction of the reefs of non-compliance with the non-retroactivity ratione personae, fundamental, non-derogable principle enshrined in Article 24, paragraph 2 of the statute. That is an essential component of the rule of law.
And what do you say in respect to this argument as regards the appeals chamber's decision in Bemba and Ongwen?
In Bemba, we were in Central African Republic, a state party. In Ongwen, we were in Uganda, a state which had first accepted the jurisdiction of the court and then became a state party. So this is not the same situation.
I see. So you say the defining difference is whether a country is a state party or isn't a state party.
I'm not the one saying that. The appeals chamber said it.
Yeah.
In OA8.
Yeah. All right. Thank you.
I have no doubt, your honors, that I fully measure the radical divergence between the public opinion and expectations expressed by the Office of the Prosecution, the views and concerns of the victims expressed by the legal representatives, and the consequences of the strict and plain application of the law exposed by the defense. Mr. Abd-Al-Rahman was found guilty of all crimes he was accused of on 6 October 2025. But there is no imprisonment sentence applicable to him other than maybe a term of 7 years if you compare count 4 to Iraba. This is abrupt. I dare even say it is vertiginous. But this is the only reasonable consequence of the application of the law of the court, especially Article 24, paragraph 2 of its statute, the non-retroactivity ratione personae principle. In introduction to my oral submissions on Monday, I insisted on the importance of this fundamental principle, a jus cogens norm, according to the appeals chamber. Jus cogens literally means constraining law. I'm convinced that you don't like the outcome of it. The prosecution does not like it. The victims will not like it. And if I authorize myself for the first time in 5 years to express an opinion based on the only findings of your trial judgment, my background working in humanitarian organizations and as a legal advisor for chambers before sister international tribunals makes that I don't like it either. But the law is constraining us all. It constrains me, in the first place, to ask you to apply no prison sentence or, at worst, 7 years sentence to my client. And it constrains you I'm afraid to accept it. Your owners can not.
That's what your submission is.
This
Mr.
is my
Lauchi.
submission.
You're not.
Everything is my submission.
Yes. Thank you.
Your owners cannot disregard, empty or nuance the non-retroactivity ratione personae principle without taking the risk of comforting the most authoritarian, non-democratic, and most repressive systems of the world, like Sudan in 2003 and 2004, and unfortunately today. The International Criminal Court will honor itself by complying with Article 24, paragraph 2 of its statute. It is a fundamental pillar of the rule of law. The only consideration that may tempt you to disregard this fundamental principle or empty it from its effectiveness are being mentioned by my learned friend in LRV this morning. Retribution to Mr. Abd-Al-Rahman, deterrence towards the other offenders in Sudan, and the satisfaction of victims. Let me address these one by one. Retribution to the old man sitting behind me is not worth the risk of sacrificing a fundamental principle of international criminal justice, such as the non-retroactivity ratione personae. As far as we can pretend to understand Mr. Abd-Al-Rahman's beliefs, it seems that a real retribution for him cannot come from the justice of men, but only from another justice. Disregarding the fundamental principle of non-retroactivity would amount to giving credit to what he represents according to the findings of your trial judgment. That is the brutality and cruelty of lawlessness. The world will be neither worse than better if Mr. Abd-Al-Rahman returns home. The fears, legitimate fears, expressed by the victims that he may start again criminal activities has no materiality is too old for that. But the world will be significantly worse if the court sacrifices a fundamental principle of international criminal justice to keep him in jail. Deterrence towards the offenders. There are two categories of offenders that your owners may want to consider. I start with the easy part. Those committing crimes in Sudan at the time I am talking. The strict and fair application of Article 24, paragraph 2 of the Rome Statute will not benefit those. They are committing international crimes under the empire of the International Criminal Court, which they entered on the 31st of March 2005 and never left. If some of these get arrested and transferred to this court, let's all wish so, your sentencing judgment, applying no prison sentence to Mr. Abd-Al-Rahman out of respect for the principle of non-retroactivity ratione personae, will have no bearing on their case. The second category are those already wanted by the court and still at large: Harun, Hussein, al-Bashir, and Banda. Very easy regarding the last one. The crimes Banda is charged with were committed in 2007. That is under the rule of the Rome Statute. Non-retroactivity ratione personae cannot benefit him. I turn to the three others, and they have prepared a chart to help in my explanation. As you can see on this slide, these are but a few examples of crimes falling under the jurisdiction of the court that were committed in Darfur, Sudan, after 31st of March 2005, that is, once the law of the court had become applicable in Sudan. These examples were found in open source with the limited means available to the defense team. The defense has no doubt that the Office of the Prosecutor investigators already know more and are capable of investigating other crimes committed over that period. In 2008, in West Darfur, various localities were attacked in a coordinated action between Janjaweed and Sudan armed forces.
Oh, we can, you don't need to read this out. We can all see
Okay,
it.
I summarized just to say that with these only 4 examples running from 2008 to 2016, Mr. al-Bashir was the president of Sudan all over the period. The rule of non-retroactivity would not apply because it's after 2005, so the age limit under Sudanese law would not be applicable. He can be sentenced. The same for Minister Hussein, except the last one in 2016. I speak...
Mr. Archie, I'm going to stop you because this is all speculation as to whether they would be charged or whatever.
I fully agree.
We are just here, just a moment, let me finish, please. We are here simply to deal with the case of your client and not worry about people who are not before the court.
Okay. Madam President, I just wanted to reassure you that not applying a prison sentence to my client will not prevent the prosecution of other people like these, the 3 gentlemen named in this chart by this court. I stop here. Anyway, I doubt the Office of the Prosecutor would suggest that Harun, Hussein, and al-Bashir only committed crimes before the adoption of Resolution 1593. That gives a lot of solution to prosecute them. This is the proper answer to my learned friend of the
Your
prosecution
Honor,
yesterday.
Your Honor, I'm sorry, I thought you made a ruling.
Did. You're still carrying on, Mr. Lauchi.
I need to reply to what my learned friend in the prosecution said yesterday when he said, you know, you just have to wait home until you are 70 and then you come to the court and you will be safe because you cannot be in jail. I need to answer this argument.
Yes, well, that I don't think you need to answer that. I think that was Mr. Nichols in full flow, and I don't think you need answer it. And this is not an answer to it in any event.
Yes, it is. I want to say that it's what matters is precisely what the Office of the Prosecutor is prosecuting. Not my colleague, not those sitting on this bench, but their predecessors made the fundamental mistake of prosecuting crimes committed before resolution.
Mr. Lauchi, I can assure you, all 3 of us here have absorbed your argument that the only sentence your client can receive is one that means his immediate release.
If you are convinced by my demonstration or IRA, yes,
that is your argument, that is your submission, and we've heard it.
Finally, the last element that may tempt you not to follow my submission after retribution and deterrence is the satisfaction of victims. That is certainly the most difficult aspect and the most painful. It is not my intention to address it the easy way by referring again to the quotations from the LAV written submissions where the victim says they are expecting justice, not vengeance, and try to suggest that they will celebrate your judgment releasing Mr. Abd-Al-Rahman. Certainly, I will not do that. The victims deserve better and more. The decision that I am asking you, Your Honors, to take today will be terrible for the victims. It will take much more than that for them to accept it. Outreach services will face a heavy burden. As I always said to them, to the outreach services, the defense will avail itself without limit to support outreach activities in explaining the rationales of your chamber's decision and the reasons why it was the only fair solution compliant with the Rome Statute. The most important message to convey to the victims will be explaining that the release of Mr. Abd-Al-Rahman has no impact on your trial judgment of 6 October 2025.
Mr. Lauchi, I'm now going to stop you because I don't think you appreciate just how insulting your present submissions are to this bench. You have urged us that the Rome Statute allows only, as you say, the sentence that would have been applicable in Sudan. That is your submission. The prosecution and the CLRV disagree. But what you are now suggesting is that we would deliberately flout the law, if you're right, because of the fears of victims or what might happen to
it's not my
other
suggestion.
accused. We will, as you suggest, submit, and as we have taken an oath to do, apply the appropriate law, Mr. Lauchi. The fact that if we apply it in your favour, it may not go down well with the victims, is obviously not something that we can take into account. We are obliged to follow the law. We will do so. Now, is there anything more you want to say?
I understand, Madam President. I thought it was useful to encourage you, but I see it is not useful. So I will stop here for that. The last thing that I would like to say is that, because that's also important for the victims, your decision on the sentencing will have no impact on the full application of Article 75, Paragraph 2 on reparations. Even without a present sentence, Mr. Abd-Al-Rahman would remain convicted, and the condition for reparations to victim will remain fulfilled. Releasing Mr. Abd-Al-Rahman, pursuant to Article 24, Paragraph 2 of the Statute, will not prevent reparations for victims. To some extent, one may say that it will make these reparations even more imperious. And finally, and that's also the reason why I skipped a paragraph, sorry. The reason why the reparation will happen anyway is that if Mr. Abd-Al-Rahman gets to be released, the defense will, of course, have to see with him what are his intentions regarding his appeal. Without making any presumption as to his decision, it may well result in your judgment of 6 October 2025 reaching its finality much sooner than expected. The moment is solemn. Your honors are facing a difficult decision. The defense did its utmost to assist them in taking it. I have no more to say. I shall stop here and, with your permission, give the floor to Mr. Abd-Al-Rahman for his last words before this chamber.
Yes, Mr. Al-Rahman, I gather you want to address us. You may do so.
In the name of Allah, the most merciful, the most compassionate, I ask God to accept the victims and martyrs in Al-Fashir and in Kordofan, and to heal the wounded and free the prisoners. We ask the warring parties to stop the fighting in Al-Fashir and all over Sudan. I thank the honorable judges for the opportunity to speak with you today at the conclusion of my trial. My defense team has explained that judgment, your judgment, which finds me guilty of many crimes. The defense team has also explained to me the ruling and that it opens the door for the reparations phase for the victims. I'm glad, thank God, that the victims of 2003 and 2004 will finally be able to receive reparations. They have suffered a lot, waited long, and they are still suffering. They are in dire need for these reparations. Since my first discussions with the Council in June 2020, he informed me that of the existence of reparations for the victims before the court. I didn't know this before I surrendered myself. I think this is great. During the trial, I heard accounts of the attacks in Kudum, Bendisi, and Mukjar, and the executions in Mukjar and Dilej. It was horrible. The people who underwent these events have undoubtedly suffered greatly. They and their families continue to suffer today. Since these people have suffered, the least that can be done is to provide them with reparations. It wasn't necessary for them to wait 5 years until the end of this trial to do so. I have asked my lawyer to propose the start of reparations and that they begin immediately since 2020. But the court has refused and said that it must wait. The victims had to wait, and they suffer. However, today that the trial is over and the conditions set by the court to award reparations to victims has been met. Therefore, I ask again the victims of Kudum, Bendisi, Mukjar, and Dilej, those who you have heard their tragedy and suffering, they need reparations and they have the right to them. They have been long overdue. Let these reparations be provided to them without further delay. I have nothing. I have been poor for a long time. The life of my family depends on the little that we have. I wish I had the means to alleviate the suffering of the poor, which is the case of all the victims of war in Sudan. If I had the means, I would have done that without hesitation, but I don't have the means. Mr. Lauchi has explained to me that there is a trust fund for victims that can provide them with compensation. I don't know how this fund works, but it is a good initiative. At my request, the Council has visited this fund and discussed with them how to enable the victims of Sudan to receive reparations and how I can contribute. My lawyer told me that the fund receives donations that can be allocated to the victims of Darfur. From this rostrum, I make a solemn appeal to the generosity and humanity of all states of the world to provide charitable funds, and to all the people of conscience to make voluntary contributions to the fund for the benefit of victims in order to finance the reparations allocated. Allocated to the victims of Darfur. The Sudan is a country devastated by war. And this war brings with it famine, epidemics, and much suffering endured by innocent citizens who only want to live in peace. Your donations will help alleviate the suffering of the victims of the Darfur War of 2003 and 2004. The victims of today also need assistance, especially humanitarian assistance and peace. I would like also to express my gratitude to the defense team for the efforts in seeking to collect donations, and I urge them to continue this work throughout the trial. I have been praying every day to God for the salvation of the victims and to end their suffering and that of their families. I continue to pray today as the epidemic of war continues to devastate Sudan. What's happening today in my country is a cause of sorrow and despair. People are still suffering, dying, and fighting among themselves, while all of us should have lived in peace and unity under God across our different tribes, cooperating to rebuild our beautiful and bright Sudan and make it fruitful to feed our children, secure a future for them, and bring them out of the miserable situation we are living in today. Misery, despair, and war are not inevitable. It is up to every man of goodwill, no matter his status, tribe, or profession. It's up to them to reject war, to revive hope, and to seek to lift the united Sudan out of misery through the path of God and peace, which lead to harmony and prosperity. I'm an old man. I have no resources, far from my country. My life is coming to an end, and I will soon stand before the justice of God. I await it, because God is forgiving and merciful. Since the court has allowed me to speak, and my speech will be broadcast and heard, especially in Sudan, I would like to take this opportunity to make a simple and last sober appeal for peace and reconciliation. I speak as a simple man, a Sudanese, a father, an elderly man, on the cusp of meeting his Lord waiting for his judgment. I have no authority, and I have nothing but prayer and supplication. I appeal to my compatriots, regardless of their tribes, Arabs or non-Arabs, all of whom are equally Sudanese, especially the youth, to lay down their arms and refuse the fight, and to reconcile. I implore the military in the Sudan and all those who have authorities over my Sudanese brothers to put an end to the fighting and to work hard for the return of lasting peace and prosperity. To the warring parties, Major General Abd-Al-Rahman, Major General Hemeti, Abd-Al-Fattah Duglo, you have children. The war you are fighting is a curse for your children, for the salvation of your children, your grandchildren, and the children of Sudan. I ask you as a father, a grandfather, to put an end to this war. It's not necessary. Honorable judges, thank you for giving the floor to an elderly man who is suffering. You are fulfilling your duty to achieve justice as much as human justice allows. My fate is in your hands. The rest of my life is not long. And finally, I ask you not to look only at the elderly man standing before you, regardless of the charges you see against me, because behind this man is a family, children. He has family, children, grandchildren, living in a country devastated by war, deprived of resources, so much so that his children had to drop out of school because they need him. Please do not forget them and keep their chance to see him one day before I myself stand before God. I thank you very much. May God bless you and reward you. Thank you.
Yes. Very well. If there are no other matters, then that concludes this hearing. I repeat what I said, but I think it was in private session, that we will deliver a sentence on the 9th of December at 9:30 in the morning.
All right, we will